Hello everyone, I'm Professor Dr. Ashok R Patil, heading Consumer Chair at National Law School of India University. This chair was established by Minister of Consumer Affairs, Government of India. I'm also coordinator for postgraduate diploma in consumer law and chief editor of Scopus Journal, International Journal on Consumer Law and Practice. This video is for Department of Justice, Government of India, DISHA Legal Literacy and Legal Awareness Project. I also thank CEERA Center for providing this opportunity. Through this video, we are going to learn some of the important features of consumer protection law in India. As you know, our father of a nation, Mahatma Gandhi, said, "The customer is the most important visitor of our premises. He is not dependent on us. We are dependent on him. He is not an interruption on our work. He is the purpose of it. He is not an outsider on our business. He is a part of it. We are not doing him in a favor by serving him. He is doing us a favor by giving us an opportunity to do so." If everybody understood this statement, then there is no need for consumer welfare legislations, enforcement authorities. But things are not happening in that way. That's why now the government of India has come out with consumer welfare legislations. As you know, Consumer Protection Act 1986 was developed by or enacted by India on the basis of United Nations Guidelines on Consumer Protection 1985. And before that, March 15, 1962, John F. Kennedy introduced consumer rights in US Congress. That's why throughout world we celebrate International Consumer Rights Day on March 15th. Similarly, 24th December, we celebrate it as a National Consumer Rights Day because Indian government enacted Consumer Protection Act 1986, and that's why we celebrating 24th December as a National Consumer Rights Day. This Consumer Protection Act 1986 was enacted, and other welfare legislations enacted on the basis of our constitution, which is the supreme. Even though every businessman can do business in India under Article 19(1)(g), which is a fundamental right, but it's not an absolute fundamental right. State can impose reasonable restrictions on trade in the interest of public. And also Article 21 talks about right to life with dignity means without exploitation. It is the state duty to guarantee that everyone in this country has a right to live with human dignity and is free from exploitation. And there are two directive principles under the Constitution which protects the consumers. Article 38 state to secure a social order for promotion of welfare of the people, and Article 47 duty of the state to raise the level of nutrition and standard of living and to improve public health. So these rights, these fundamental rights and duties imposes duty on the state to protect the consumers. In that angle, 86 Act was enacted, but change in the trade, business, digital era, Government of India thought of coming out with a new legislation, Consumer Protection Act 2019. So this particular legislation repealed the 1986 Act. And let us look into this legislation, bird's eye view, I can say. So this chapter has, this particular legislation has a 8 chapter, and 107 sections, and it is divided into uh, 8 chapters. First, as a preliminary, it is applicable to whole of India, and second chapter talks about consumer protection councils at the district level, state level, national level. These councils are recommendatory in nature, and these councils don't have any quasi judicial powers. Just they can uh, in a meeting discuss the issues in the district level, state level, national level, and refer it to the concerned consumer ministry. They will take those recommendations and change the policy. Next, third chapter is consumer protection, central consumer protection authority, which was not there under the 86 Act. First time we are introducing this central authority under Consumer Protection Act. This authority has a lot of powers, including suo motu admitting the cases, search and seizure order, recall of goods. It has a investigating wing. Only the consumers can file a case or file a complaint here against the unfair trade practice, misleading advertisement, endorser's liability. So, in these types of exploitation, consumer can file a complaint to the central authority. Only one point has to satisfy by the consumer, one who is filing a complaint to the central authority, is that particular exploitation should be affecting consumer as a class. If it affects consumer as a class, then central authority will admit the complaint, and through their investigating wing they will investigate and they will take necessary action. So to file a complaint before central authority, one must have the consumer as a class, that particular issue or exploitation should affect, then only central authority will take up. And another very important thing, to file a complaint before central authority, there is no need for you to prove as a consumer, as consumer definition given under Consumer Protection Act. Even by seeing the misleading advertisement on TV, you can file a complaint against that particular advertiser or a company which is advertising doing misleading advertisement or giving misleading advertisement. So along with your complaint, you have to support the documents by which the central authority can read your complaint, understand, and through supportive document they can get a prima facie case, and they do investigation and they take necessary steps against the wrongdoer. So this is a very important thing, and even central authority can file a complaint before criminal court to take necessary action against uh, the unfair one who is doing unfair trade practice, misleading advertisement, and even endorser's liability. So that's why we can say that the Central Consumer Protection Authority is a very strong body. It is established on the line of Federal Trade Commission of USA. So we can see a lot of changes in the future because of this central authority, and already a lot of actions are taken by this central authority. Then next chapter comes the Consumer Dispute Redressal Commission. So we kept the same three-tier redressal system as it was under the CPA 1986. It has a quasi-judicial powers, and three-tier redressal system means at the every district throughout India, district consumer dispute redressal commissions are established, and at the state level, state consumer commissions, and national level, national commission. So depending on the pecuniary jurisdiction, territorial jurisdiction. Complaint can be filed before District Commission, State Commission, National Commission, and appeals from National Commission, it goes to Supreme Court if substantive question of law is involved. So we'll discuss in detail on in territorial jurisdiction, pecuniary jurisdiction, so all those things in later slides. Next chapter is mediation. So first time we introduced this chapter, which was not in the 1986 Act. So even though we say that Consumer Commission should dispose of cases within 3 months from the date of notice served to the opposite party, in case of lab test 5 months, but we are not achieving that particular object properly. And because we have a federal system, central government cannot interfere too much in the state administration. So it is the state government duty to appoint the members, establish the district commissions wherever it is needed. So all those things, but it is not happening satisfactorily. So that's why a lot of pending cases are increasing in district commission and state commission. That's why the central government thought of introducing mediation chapter under the Consumer Protection Act. Mediation, as you know, it's a same definition which is used in other legislations also. It originally first time in India, through section 89 of Civil Procedure Code, we used along with the other alternative dispute resolution, and mediation is the only one which is suitable under the Consumer Protection Act, not other alternative dispute resolution. So mediation, as you know, it's a voluntary process. Both parties voluntarily settle the matter outside the commission, Consumer Commission. If parties wants to settle the matter through mediator, then they can request the Consumer Commission and consumer in a written form, and Consumer Commission allow you to settle the matter through mediator, and they will appoint a mediator for this particular case. And both the parties independently, whenever, wherever comfortable, they can meet with the mediator and settle the matter. Once you enter the mediation process, it is not mandatory for you to settle the matter through mediation. If you are not happy with the way it is handled or procedure is happening, or you are not satisfied with the discussion or resolution, then you can say no to the mediation and come back to the Consumer Commission. And once it comes back to the Consumer Commission, then it will go as per the proper procedure under the Consumer Protection Act. If it is settled, then mediator will submit the settlement agreement with his signature and both parties' signature as per their terms. The settlement has happened, and that will be submitted to the Consumer Commission, and Consumer Commission puts its seal and signature. Then that becomes the final order of the Consumer Commission. Once it is a final order is given, no appeal is available for mediation settled award. So that is the way how it works. And mediation is a win-win position. Both parties settle the matter happily, and they go back to home happily, and their relationship, everything, it will be smooth. So that's why we may call it as a win-win position. And now the every district, state and national commission have to establish mediation cell at their place, and also they have to prepare empaneled mediator who are trained as a mediator. Then they will be appointed for these mediation settlement procedure. Then next chapter is product liability. Product liability is also new chapter under 2019, which was not there under 1986 Act. Even though it was not there, but under the 1986 Act, manufacturers are held liable, service providers are held liable for their defective goods or deficiency in service. Only here under 2019 Act, independent chapter is inserted and in detail discussed when manufacturer is held liable, when product service provider is held liable, when seller is held liable, specifically expressed under this chapter. And seventh chapter is offences and penalty, again which was not there under 1986 Act. Newly introduced this chapter under seventh chapter, offences and penalty. Here the aggrieved party can approach the even to the criminal court under what on the provisions mentioned under offences and penalty. And lastly, miscellaneous, where many provisions are discussed about, especially when on which topic the central government can make rules, state government can make rules, then Supreme Court, National Commission, State Commission can make a regulations on that, and also it talks about the particularly special. This is an additional remedy. It's not a derogative of any other law. So that provision is also mentioned under miscellaneous. So this is a bird's eye view I'm giving you. Then specifically I'm taking some of the definitions which are important for you to understand Consumer Protection Act. Here, complainant, who can file a complaint? Who can file a complaint? So that person is called as a complainant. Consumer himself can file a complaint, and any voluntary consumer association can also file a complaint. Central government or any state government can file a complaint. One or more consumers, where there are numerous consumers having same interest, can file a complaint. In case of death of a consumer, his legal heir or representative. In case of consumer being a minor, his parents or legal guardian. So these are the people other than consumer can file a complaint before Consumer Commission. And who is a consumer? Who is a consumer is very important definition. If you understand this definition, then only you can understand when, where, or is it possible for you to file a complaint under Consumer Protection Act. All those things you can understand. Here, in simple way, this consumer definition is having 3 paragraph, now 4 paragraph. So first paragraph, paragraph talks about the goods. Second paragraph talks about services, and third and fourth paragraph gives an explanation for 2 words. So let us look into the first paragraph. Consumer means any person who buys any goods for consideration which has been paid, promised, or partly paid, partly promised, or under any system of deferred payment. So first part in first paragraph talks about consideration. It means there should be a consideration. It's a mandatory. Then middle part talks about any user of such goods other than the person who buys such goods for consideration is also consumer. Third part or last part of the first paragraph gives explanation. Whosoever purchases goods for resale purpose or commercial purpose, that person is not a consumer. Let us take an example. If father purchased a laptop is a goods. So that laptop, if it is defective, then father can file a complaint against the defective laptop manufacturer or seller. And if that laptop is given to his daughter, and the daughter was using that particular laptop, because of the defect in the laptop, if she injured, she can also file a complaint. She is also consumer under this definition. Only thing is the exception that nobody should fall under exception. If they fall under exception, then that person cannot file a complaint under Consumer Protection Act because that person is not satisfying paragraph 1 of the consumer definition. Second paragraph talks about services. So any person hires or avails of any services for consideration which has been paid or promised or partly paid, same consideration part should be there. Middle part again talks about beneficiary. Beneficiary of such services is also a consumer. And last part of the second paragraph talks about exception. That is, does not include a person who avails such services for commercial purpose. So let us take one example. If a father admitted his son to the hospital, and here father paid the consideration, father is a consumer, and father paid the consideration for his son for treatment. So if son is injured because of the negligence of the doctor or hospital, son is also consumer. Son can also file a complaint against the doctor or hospital. So this is the way how the consumer definition is interpreted. So two explanation clauses are given. The expression commercial purpose does not include use by a person of goods bought and used by him and services availed by him exclusively for the purpose of earning his livelihood by means of self-employment. So here, exception to exception. I'm giving you one simple example. On that basis you can understand. If auto rickshaw, if a person purchased a auto rickshaw and auto rickshaw is used for the commercial purpose, if you use for commercial purpose, first two paragraph talks about exception. But if you prove that you yourself driving that auto rickshaw and whatever earnings comes from that work, you are using it for livelihood, then you are still falling under consumer definition. So auto rickshaw, the purchaser, the owner is still a consumer even though he is using that auto rickshaw for the commercial purpose, because he himself driving that auto rickshaw, and whatever he earns from that act, that work, that is used for livelihood by means of self-employment. And clause B was inserted under the 2019 Act, which was not there earlier. The expression buys any goods or hires or avails any services includes offline or online transaction through electronic means or by teleshopping or direct selling or multi-level marketing. Earlier also under the 86 Act it was included, but here expressly mentioned under the consumer definition, online or offline, in whatever mode you have used and purchased the goods or hired the service, everything coming under the Consumer Protection Act. So there are two changes happened, especially on jurisdiction. One on territorial jurisdiction, especially in territorial jurisdiction earlier under the 86 Act, on the basis of total compensation, what we have claimed before the commission, on that basis we used to decide pecuniary jurisdiction of district commission, state commission. On that basis we used to file a complaint. But now it is not on the total claim, how much you want from the opposite party. Now pecuniary jurisdiction is decided on the basis of value of the goods or services paid as a consideration. On that basis it will be decided, not on total claim. So that is a pecuniary thing. And second one is about where you will file territorial jurisdiction. So earlier the first two clauses were there, where opposite party or parties resides carries on business, personally works for gain, or has a branch office, or where cause of action wholly or in part arises, so there you can file a complaint. So under 2019 Act, last new clause was added, very important clause, need of the hour, that is the complainant, the the complainant, wherever he resides or personally works for gain, in his place he can file a complaint, which was not there under 1986 Act. This helps the poor consumer or any type of consumer comfortably. They can fight against a wrongdoer sitting or in his place where he is residing or personally works for gain. As I mentioned, this is a three-tier redressal system and pecuniary jurisdiction, up to 50 lakh district commission, more from above 50 lakh up to 1 crore state commission, and above 1 crore national commission. And this 50 lakh or all this pecuniary jurisdiction decided on the basis of value of the goods or services. For example, if you purchased a car by paying around 49 lakh 49 lakh, and value of the car is 49 lakh, and it was not good condition, you repaired it, you spent money on the repair work, again you can say that 10 lakh you have spent. So now mental agony, all those together, now you want to claim 1 crore. So your claim is 1 crore, but value of the subject matter is 49 lakh. So you have to file the complaint on the basis of value of the goods. Value of the car is 49 lakh, hence you should file it before, it's a less than 50 lakh, you should file it before the district consumer commission. But you can claim more than 50 lakh, that is you can claim 1 crore before the district commission. So that is the change made under 2019 Act. Coming to the defect definition, so Consumer Protection Act will not explain each product what should be the standard and what should be the defect. So this defect definition is a general definition. So it will not give description for every product what is defect. So but in general it says defect means any fault, imperfection or shortcoming in the quality, quantity, potency, purity or standard which is required to be maintained by or under any law for timing in force or under any contract express or implied as is claimed by the trader in any manner whatsoever in relation to goods. So in simple way, what I want to impress upon you, each good or each product standard is prescribed by that particular sector legislation. So as per that standard, these goods are sold. So for example, Food Safety and Standard Act, it will prescribe what is the standard, how much color can be added, how much chemical can be added, what should not be added. So everything prescribed under Food Safety and Standard Act rules, regulations. So that's why this particular sentence, under any law for timing in force, it puts a duties and responsibilities on the trader or businessman what to do, what not to do. If they are not following that, and especially it is related to the goods, then it is considered as a defect. Even Bureau of Indian Standard Act prescribes there are a list of items which are sold with ISI mark. If those goods are sold without ISI mark, then it is an offense under Bureau of Indian Standard Act, and that particular product is a defect under Consumer Protection Act because they have not followed law of the land. So these are some of the examples for defect definition. Coming to deficiency, deficiency definition applicable exclusively for services. Defect definition exclusively for goods. If we look into the deficiency, deficiency means any fault, imperfection, shortcoming, inadequacy in the quality, nature, manner of performance which is required to be maintained by or under any law for timing in force or has been undertaken to be performed by a person in pursuance of contract or otherwise in relation to any service, and includes, see, earlier under 1986 Act these two clauses were not there. So now under 2019 they have added. What are those two clauses? First one, any act of negligence or omission or commission by such person which causes loss or injury to the consumer. And the second one, deliberate withholding of relevant information by such person to the consumer, that is also considered as a deficiency. So this deficiency is very important, and even under different service sectors, regulatory authorities are there, and they have also prescribed duties and responsibilities of the service provider. If that is not followed, then it is considered as a deficiency. So service definition, it's the inclusive definition. All types of services covered under this. Only free services are not covered, and contract of personal services are not covered under this definition. And unfair contract is newly added, and whosoever takes excessive security deposits, imposing any penalty which is disproportionate to the loss, and refusing to accept early repayment of debts, and unilaterally cancelling of the contract, and any unreasonable charge on the consumers, all these things are considered as a unfair contract. And another definition is unfair trade practice, which was there in the 86 Act. Only 3 new clauses are added. So with this I can conclude. So not issuing a bill or cash memo when you purchase any goods or services, if they are not issuing the bill, that is considered as unfair trade practice. And refusing after selling goods or rendering service to take back or withdraw defective goods, or withdraw or discontinue deficiency in service and refund the consideration, is also considered as unfair trade practice. And disclosing to other persons any personal information given in consideration in confidence by the consumer without his consent, that is also considered as a unfair trade practice. And especially under the Consumer Protection Act 2019, electronic digital era or digitalization is recognized. Complaint can be filed electronically, services can be sent to the parties through electronic mode, and with the permission of the commission, video conferencing is also allowed. So this is a very new thing has happened. With this I conclude. Thank you very much. Thank you all once again. Thank you.